And based on my books, I've talked to the media a lot, but I never actually gave a press conference before. A little strange to be sitting up here, but this event is actually held in the safe house for the Orleans Levee District, built to withstand close to 200-mile-an-hour winds for a hurricane. And I understand that as I speak, there is a tropical depression in the Atlantic forming. So it's very relevant. First, for those of you who don't know who the Southeast Louisiana Flood Protection Authority is, we were formed after Katrina. A constitutional amendment was passed to allow our formation. We are our regional board overseeing 3 levee districts on the east bank of the Mississippi River, along with St. Tammany and Tangipahoa, where there are no levee districts at this point. There is a nominating committee, which is comprised and includes the deans of the colleges of engineering in the state. Is chaired by Jay LaPierre. The Business Council has a few other members on it. They nominate the members, and the governor chooses from nominees suggested by this committee. By law, we're a 9-person board. 4 members of the board have to come from outside our jurisdiction to guarantee that we don't get bogged down in provincial issues. The governor does appoint us. We do get confirmed by the Senate, but unlike most boards in the state, we do not serve at the governor's pleasure. Once we are nominated, we can only be removed for cause. The whole idea of this board's existence was that we be independent and that we have expertise in floods. Our board does have expertise in, among other things, engineering, storm surge modeling, meteorology, coastal science, river hydrology. It is, I think, a very fine board. I'm proud to serve on it. I should have started by saying I'm John Barry. I'm vice president of the board. We do take our mission to protect the public very seriously. And because of that obligation, and with considerable reluctance, because we understand the controversial nature of the action, but with a unanimous vote, we have now filed a lawsuit against, I think the number is 97 oil and gas attorneys. I looked over there because I was about to introduce the attorneys. I just remembered I forgot to, but I'll do that after I finish my statement. So let me repeat that. The authority takes its mission to protect the public seriously, and because of that, with reluctance and recognizing the controversial nature of what we're doing, we have filed lawsuit against 97 oil and gas and pipeline companies over the industry's contribution to coastal land loss. The issue is really pretty simple. Levees and flood walls are the last line of defense to keep a hurricane storm surge outside the city. The first line of defense is the barrier islands, the marsh, and the land between the ocean and the levee system. All of those things lessen the surge which attacks the levees themselves. The industry, we understand, is not responsible for all of the coastal land loss. We know that. There are multiple causes. But the industry is responsible for a significant part of the land loss. Numerous scientific studies attest to the fact, and the industry itself acknowledges it. Throughout the state, the industry has dredged 10,000 miles or more. Throughout the state, the industry has dredged 10,000 miles or more of canals and pipelines to service the production of, this tremendous natural resource. And every inch of those canals allows saltwater intrusion, which kill plants. Their roots no longer hold the soil together, and that accelerates land loss. In addition, of course, the extraction of the volume of natural resources from under the ground also causes the surface to sink, and that's another way it contributes to land loss. Now, we are not asking or expecting the industry to fix everything. We are asking that they fix the part of the problem that they caused. We believe they're obligated to do so for 3 reasons. First, in most cases, the issues which have allowed the activity, the first, obviously I'm blowing this, at least I'm repeating it for those of you who need the actual quote. First, in most cases, the permits that were issued that allow the activity to go forward explicitly require, and the industry agreed to, they explicitly require that these canals be maintained and restored. And the industry, as I say, they voluntarily agreed to this as a condition of extracting the oil and gas. They didn't have to. If they hadn't, of course, they wouldn't have been allowed to do it. It was a trade-off. They made money, and they were expected to restore. They have not complied with these requirements. That's number one. A second ground for our lawsuit is federal law, which prohibits any activity which, quote, impairs the effectiveness of a levee, unquote. Without doubt, when you increase a storm surge by taking away the buffer of land that protects those levees, you are impairing the effectiveness of a levee. Third, there is a well-established principle of civil law going back to the 1400s called servitude of drainage. And the applicable part of that here is that this doctrine prohibits one person from doing something on his or her property which sends more water flowing onto someone else's property. So, and again, this increase of water against the levee system violates that servitude of drainage. We recognize this as a controversial action. We regret its necessity, but the industry has had years to do what it should, and in what in most instances it said it would do. Everyone else has stepped up. The citizens of Louisiana passed a constitutional amendment which sent 100% of the money that comes from the revenue from the drilling in the outer continental shelf to restore and protect the coast. The state itself, the government, discretionary spending is devoting vast sums of money to take care of this problem. Individual parishes are also spending money on their own to address these issues. The only person who has not stepped up is the oil industry. Even the federal government has just spent $14.5 billion. And the Corps of Engineers has a plan. They recognize that the Mississippi River Gulf outlet also created a lot of coastal land loss. They have come forward with a plan, also in the billions of dollars, to restore what they broke. So we are asking the same thing, that the industry restore what it broke. We're asking 2 things, really, that in the lawsuit. We're asking for an abatement of the problem, that where possible, the industry go back and do what it already promised to do, that it restore and maintain the land that was damaged. In some areas, of course, that's not going to be possible for a variety of reasons, so we would therefore look for monetary damages. Obviously, the money would come to the board. Not a single member of the board makes a single penny. from anything we get from this lawsuit. The public gets all the benefit from any money we get from the lawsuit. The money will be used to either restore coast or augment the flood protection system. I don't want to go off on a tangent, but many of you here know exactly what 100-year protection means, and it doesn't mean much. It's actually the lowest standard in the developed world for flood protection. Our vision statement, which we actually take seriously, calls for 500-year protection. And we would like very much to get as close to that as we possibly could. If nothing is done, according to the State Coastal Protection and Restoration Authority, statewide flood damages over time will rise to an average of $23.4 billion a year. For the wealthiest industry in the world to shift the burden of preventing these costs to the citizens of Louisiana is unfair, to say the least. What we hope to do is make partners of the industry and all the responsible parties, precisely as the law requires, and to ensure that those who have contributed to the problem now contribute to the solution. I will introduce not all the lawyers, but Glad Jones is the lead attorney. Jim Swanson is also involved, and Rock Palermo and Bill Guerin from Lake Charles. And Glad.
Thank you very much, John. As John said, my name is Glad Jones. I'm with the firm of Jones, Swanson, Hiddell, and Garrison. I'm proud to be here with my co-counsel this morning from Fishman Haygood, James Swanson, and from Veron Bice, Mike Veron, and Rock Palermo. I am the lead counsel in this case, and I'm very honored to take on this particular project. I think the best place for me to start is to refer you, I hope you all have a copy of the petition that was filed sometime around 9 o'clock this morning. But I can't say it any better than on page 3 in the final paragraph in that petition. This case is about the future of South Louisiana. It is also about the authority's duty to avert the dire consequences that the defendants violated with regard to their obligations. Only by making this demand, as set forth in this action, can the authority fulfill its mission and confront the unnatural threat that now imperils the region's ecology and the people's way of life. In short, its very existence. That's right out of our complaint on page 3. I would simply add that in this litigation, there'll be 3 basic questions that are going to be asked. Obviously, they'll be somewhat complicated, but in the end, there'll be 3 basic questions that are asked. Did these oil and gas companies cause damage in this area? Did these oil and gas companies damage that they caused harm to the levee authority? What are the damages? Let's start with number 1. Did these oil and gas companies cause damages? The answer is unequivocally yes. The federal government has found that they've caused damages. The scientists that have looked at this particular issue have all found that they have caused damages. And indeed, many of the oil companies have acknowledged that they have caused damages as a result of their operations. Did the damage cause harm to the levee authority? The answer is yes. As Mr. Berry just laid out, the first line of defense is a healthy coast and marshland. The levees are very much in peril if that coastal area is destroyed or impaired. What are the damages? The damages that we are seeking in the course of this lawsuit involve 2 forms of damages. 1, injunctive relief, and 2, monetary damages. If the oil companies were to go out and repair those areas that they operated in, there wouldn't be the need for a lawsuit. We wouldn't be needing to go and seek damages. But the levee authority has incurred damages in the past with infrastructure needs and will continue in the future to experience considerable damages and having to keep up and keep up the levees as a result of these defendants' actions. It's worth noting that the coastal area that sits just below South Louisiana took 6,000 years, according to well-regarded scientists, to build. It's taken just 100 years, or 1 lifetime, to destroy that coastal area. In the course of the last 25 years, government estimates suggest that it's estimated that oil and gas has taken approximately $470 billion in revenue from South Louisiana. To date, the federal government, with regard to their operations of the levees and the monetary amount of money spent, has spent in the range of $15 billion. To date, the oil and gas companies have spent zero. We need, in order to protect this fragile area of ours, and for the levee authority to discharge its mission, we need those responsible for coastal loss to step up and pay their share. And that's what this lawsuit seeks to do today. We're honored to have been asked to be a part of this. We look forward to a spirited debate over the next couple of years with the oil and gas industry and litigation. We're very honored to have our co-counsel here with us this morning, and we look forward to working with them over the next couple of years during this litigation.
Obviously, questions?
Well, John, have you heard at all, directly or indirectly, from the governor's office and how the governor or the administration feels about this lawsuit?
Well, I talked to Garrett Graves, and we did alert Garrett as far back as last December that we were likely to go this route, and when it became evident that we were definitely going this route, we told him. And you know, he's certainly not thrilled, but he's also capable of speaking for himself. I have not seen some tweets or press release. I actually haven't read, I think I've only read one of the stories that came out last night or this morning, so I'm not really up on that. In terms of the governor's office, we did give him a heads up. I understand, but have not seen a comment from his office, which sounded to me more or less like no comment.
Are you at all concerned that your term on the board is going to come up in the next year or so as your list of duties, and that it's up to the governor to reappoint you?
Well, my term actually expired June 30th, but because this is a public safety board, I serve until replaced. The nominating committee meets in October. If they forward my name to the governor, then it's up to him to decide to reappoint me. And then, of course, the Senate has a chance to confirm or not confirm it. You know, I would like to stay on the board. There's no question about that. And I also recognize that this might prevent that. I understand political realities. But for me to serve on the board is you weigh in the scale that versus the importance of restoring coastal Louisiana and protecting the lives and property of the people within our jurisdiction. Obviously, that's a pretty easy choice to make.
The oil companies have a lot of power in the state, control a lot of politicians. I mean, how critical is it to have the support of politicians to move forward with this lawsuit?
Well, I hope we have the support of everyone, not just politicians. I think, I'm hoping that it's not going to be nearly as controversial as a lot of people have predicted. I think an awful lot of people in this state recognize that the reality is the industry has been a major contributor to the problem.
Let me put it another way. Could the power of the oil companies and their control of the politicians, do you have any concern that that power and control could derail this lawsuit?
Well, I mean, you can go through worst case scenarios and hypotheticals and so forth. I mean, do I have any concern? Yeah, I guess I have some concern, but I'll worry about that when some real effort is made to do that.
Mr. Jones, do you have a thought about that?
No, I think John said it very well. I mean, here's a public servant who is doing the right thing and discharging the obligation of its organization. And we certainly are aware that there will be, a political discussion about the viability of this lawsuit. But at the end of the day, what matters is whether the levee authority is discharging its obligations to the people of South Louisiana and the greater New Orleans area. And through this action, we believe that they are. And we believe that they have a good basis for this. And if there's political fallout over it, I think what John just said to you is so be it. I mean, when you weigh the two issues, his own personal interest about being reappointed versus the critical need to get this straightened out and addressed, I mean, it kind of is what it is.
You cite in the lawsuit both.
Well, let me just go back to that other question. There is only one instance under which the flood authority would pay 1 penny of expenses. And recognizing the political reality, we did insert a clause in the contract that if the authority withdrew the suit of its own volition, then the authority would have to pay the attorneys reasonable fees plus all expenses, which would certainly probably be in the millions, I would think. So that clause is in there because we understand everybody's terms are staggered, they're 4 years. But over a number of years, if it were really important to any governor to make this a litmus test for being on the board, he could create a board, or she could create a board that decided to withdraw the suit. And in fairness to the attorneys who will have put in tens of, if not hundreds of thousands of hours and spent an awful lot of money on scientific research, then that clause is inserted. So even if I'm off the board, then I think this case will probably go forward. So
John,
let me answer John's
Well,
question
I'm
first.
going to go in a different direction, actually, based on what you said. This governor he did a sort of victory lap on the barrier islands last weekend, talking about how he has spent more money than any other all of the other governors combined on coastal projects. It's a relatively small amount of money that you've spent so far in the total scheme of things. Should this governor manipulate the process or through, whether it's good or bad, exercise his powers and see that this lawsuit is pulled, what would that say about this governor's commitment to the coast? Or just what does it say about the governor's commitment to the coast based on his response to this lawsuit?
Well, honestly, so far, I think the governor has been committed to the coast and has done some very good things. And the master plan of the CPRA received almost unanimous praise in the scientific community and the environmental community. And it actually would not be possible for the governor, I don't think, not one governor, his term would expire before too many seats came up on the board, for this governor to gain control of the board using a litmus test about withdrawing this lawsuit. But I'll just wait and see. I haven't had an opportunity to talk with him on this. I haven't seen him much since he became governor, but actually prior to that, I talked with him on, we weren't best buddies, but I know him, and we on occasion talked very, very long time over some of these issues.
The lawsuit talks about, it cites both state and federal law, but of the $470 billion that you mentioned that the industry has reaped in benefits, a lot of that benefit stayed in Louisiana. It went to state budgets and universities and tax revenue and all the rest. And there may have been this vague thing in the state law that said you got to close the canal, but there clearly hasn't been, regulatory follow-up from a state standpoint, either legislative or the regulators. And now, decades later, somebody comes along and says, hey, you didn't do what you were supposed to do. I mean, how much of an obstacle is that to overcome in this process?
I'll let Glad take it in a second, but I will make one comment. I mean, the damage really is ongoing. The servitude of drainage, well, I'll let Glad talk to the legal aspects. But you're really going to say that because the damage is owed, even though it threatens to destroy New Orleans, that they don't owe anything? I don't think that's a reasonable position to take.
Let me just address that in two pieces. The first one is the notion that there's some vague obligation to restore or close the canals. I want to be very specific about this, and this is going to be the subject of some debate, but on this one I'm going to win. They entered, the oil companies that we named, the vast majority of those oil companies, entered into permits with the federal government that specifically called for them to maintain their operations as designed in those permits, and at the conclusion of their work in these specific areas, they agreed, in the vast majority of cases, to restore those areas that they dug canals in or built other berms, etc. That wasn't something vague. It was a part of the condition that allowed them to go into this area, and it was done with a very good reason. Because if you cut and you slice and you dice these canals and you let that Gulf of Mexico intrude further and further and further into what is otherwise a brackish marsh, you're going to destroy that marsh. And that's what happened. And that's not Glad Jones, the lawyer, on behalf of the authority speaking. That is multiple scientists who have come to that conclusion. I dare say it's so well established that the oil companies will not be able to disagree with that point. That when Tennessee Gas put a pipeline from the Gulf of Mexico that runs all the way up to Philadelphia and New York, that conduit, for example, allowed, and they actually put 3 or 4 pipelines there, when they didn't repair that area, that conduit, allowing that seawater to run up into the upper marsh area just south of New Orleans, that is the genesis, the beginning of this problem. And they had a duty, not only an express duty, but I would dare say a moral duty, to come in and fix the marsh area that their operations damaged. Now, with regard to your question on, this happened 50 years ago, be very clear about this. It is happening as we all sit in this office today. We have lost, one of the estimates is 1,900 miles, the size of Delaware, in terms of this coastal loss over the last 80 years. Remember, it took 6,000 years to build it, to get to the point where it serves as the primary defense from hurricanes for this city. It took 85 years on the oil and gas companies' watch to destroy it. So, as this is continuing today, we intend to ask that the oil companies fix what they damaged. There is also, in addition to the express obligations that the oil companies agreed to, John mentioned that there's this legal theory under Louisiana law, the servitude of drainage. It seeks injunctive relief. It says, oil companies, go out there and fix what you messed up, the mess that you made, so that this city and the levees are not under threat by the alteration of what was there naturally for 6,000 years. That happens, we do not believe that can be, that claim could in any way, form, because it's ongoing, the damage, be dismissed because of some statute of limitations or prescription argument by the oil companies.
How much money are you looking at as far as these damages? Do you have a number? Because you keep talking about monetary damages if they don't fix the problem. What kind of numbers are we looking at?
Well, let's start with, if they don't fix the problem, then the state of Louisiana, the citizens of the greater New Orleans area, and the levee authority are going to be responsible for doing it for them. And if that's the case, the damages will reach well into the billions of dollars.
You mentioned statute of limitations. Is there any kind of a statute of limitations on these?
We don't believe that any
requirements?
statute of limitations or prescription, as we call it in Louisiana, would apply here. We fully recognize that the oil and gas companies will say that these claims are too old and we can't pursue them, which frankly we think is a little silly. We think it's a little silly that given the level of damages and the threat that those damages present to the greater New Orleans area and the 1 or so million people that live here, but it's a little silly to say that statute of limitations bars those claims.
Is there a provision that has a statute of limitations?
There are various provisions in statute of limitations, but there are big exceptions to those if the damage is ongoing, which we believe, we don't think there's any debate in the scientific world that the damages are ongoing. With regard to the servitude of drainage, we believe that claim cannot prescribe if the damages are continuing to the levee authority and will continue into the future.
While the suit is pending, will the lawyers be collecting the costs of extra witnesses and other things?
Yes, as I said earlier, the only way there will be any cost to the authority is if the authority withdraws from the lawsuit, in which case we will be responsible for no doubt, quite a bit of money.
97 defendants, it seems like you've got to, have you contacted all of these companies? What's the next step? Because obviously this is a big lawsuit, potentially with billions of dollars on the line.
I'll let Vlad.
This morning,